All right, now we have looked at multiple sections on wills. We've looked at structure and safekeeping. We've looked at what constitutes the will, including incorporation by reference, the codicil. We've looked at the will meaning, including default rules like anti-lapse, abatement, ademption, and ambiguity. And now we address how to revoke a will. From last class, we were focusing on will construction, looking at the general rules of construction. That's first. You might look to extrinsic evidence just to come back and say that there is no ambiguity. However, if you find that words are ambiguous, you then need to identify the ambiguity as a latent or patent ambiguity and then apply the respective extrinsic evidence rules. Keeping in mind that courts are very reluctant to reform a will, to correct mistakes. We look at methods of will revocation, and there are primarily three. Physical act revocation, which requires the intent and the act to the will itself. Subsequent instrument, so by using the language, I hereby revoke my prior wills, that is an express revocation in a subsequent will that will revoke a prior will. And keeping in mind that express revocation takes effect immediately. You can have implied revocation where the two wills are so inconsistent that they can't be read together. And you can have automatic revocation by divorce or marriage plus subsequent instrument, in which these events occur and your will is automatically revoked. With respect to the divorce, it's automatically revoked just with respect to those provisions relating to the surviving spouse. All other provisions of the will stand. In the N. Ray Wolf's will, this is a implied revocation where the argument is whether or not these two wills, the July will, which left land to Luffman, and the August will, that being the subsequent will, whether they are so inconsistent that they cannot be read together, and that is because the August will did not include an express revocation, and so the question becomes, can we carry out both July and August will? The Friedman case is a Maryland case that looks at Maryland's revocation statute and tries to determine whether or not the family members of an ex-spouse take. There was a divorce, and so the statute clearly articulates that provisions relating to the spouse are revoked. But what about the relatives of the spouse? So based on a statutory construction of the revocation statute, the courts ultimately determined that under 4-105, the relating to, all provisions in the will relating to the spouse must have some purpose in the statute. So we looked at some statutory instruction of Maryland's revocation statute. The Carter case, very important in terms of the physical act revocation, keeping in mind that it's somewhat referred to as a conditional revocation. Had I known will number 2 would not be effective, my marks on will number 1 would not have taken place. Okay? So those are the things that you need to think about. There's this concept of dependent relative revocation. Comes up quite a bit when people try to modify a provision of the will. Keeping in mind that you can you can revoke without the formalities, but you cannot modify, you cannot update. So I can get rid of a general bequest, $10,000 to Sam. I can mark that out. There is partial physical act revocation, but I cannot change the bequest to Sam from 10,000 to 20,000 to 5,000, okay? And so the question becomes, would the testator prefer just go back to the original provision unmarked as opposed to leaving the beneficiary nothing? And that's the concept of dependent relative revocation, and we will take a look at the Carter case on that. What about revival? How do you bring back a will? Well, it doesn't happen automatically. So will number 1 says I leave everything to Sam. Will number 2 has an express revocation or implicitly says I leave everything to Sally. I physically destroy will number 2, leaving everything to Sally. It doesn't bounce back to everything to Sam. That's the concept of revival. You need to take some type of an affirmative act to revive a previously revoked will.